Well, hello all, and welcome to this Federalist Society virtual event. I'm Caroline Bryant, and I'm Associate Director of Practice Groups with the Federalist Society. Today, we're excited to host a courthouse step decision on Gonzalez v. Trevino. Our speaker today is Anya Bidwell. Anya is a senior attorney at the Institute for Justice, where she leads the Project on Immunity and Accountability. Anya also serves as an advisor on the American Law Institute's Restatement of the Law Constitutional Torts Project. Anya has terrific expertise in First Amendment retaliation, including arguing our case, Gonzalez v. Trevino, before the United States Supreme Court. On June 20th, the court ruled the petitioner, Ms. Gonzalez, should be able to proceed with her First Amendment lawsuit against officials who engineered her arrest. If you'd like to learn more about today's speaker, her full bio can be viewed on our website, fedsoc.org. After our speaker gives her presentation, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speaker, not the Federalist Society. With that, Anya, thank you so much for joining us, and the floor is yours.
Thanks, Caroline. Hi, everybody. Thank you to the Federalist Society for putting together this event. I'm always happy to talk about my cases, especially after we get a favorable decision. The subject of this teleforum, as Caroline mentioned, is this term's biggest blockbuster. Gonzalez versus Trevino. It is a First Amendment retaliatory arrest case. And the question the court had to answer was, what kind of evidence are plaintiffs allowed to allege at the threshold stage in order to be able to proceed with their lawsuits? Before Gonzalez, courts like the Fifth Circuit, whose decision we're challenging, thought that the only evidence allowed was direct comparators of similarly situated people who engaged in the same conduct but were not arrested. So, for example, a jaywalker could not claim that they were arrested not for jaywalking, but because of their speech, unless they could point to another jaywalker who jaywalked under the exact same conditions but was not arrested. After Gonzalez, it is clear that the only limit on this evidence is that it must be objective. So as long as this objective evidence, in the court words, makes it more likely that an officer has declined to arrest somebody for engaging in such conduct in the past, this threshold requirement is met. We're obviously very happy with the result. I'm sure that some folks who supported us in this effort are on this call, and I'd like to thank them for all of their help. Before I dig deeper into the decision, let me briefly discuss the facts of the case and really how typical these kinds of cases are. So my client, Sylvia Gonzalez, she successfully ran for a city council seat in Castle Hills, Texas, on an anti-establishment platform. As her first act in office, she organized a non-binding citizen petition calling for the removal of the city manager. The petition was presented to the council during Sylvia's first council meeting. The problem for Sylvia was that the city manager had big establishment supporters, the mayor and the police chief. They were worried that Sylvia's efforts would bring back the old city manager, who was not a fan of their initiatives, shall we say. So they decided that Sylvia needed to be removed from office and also serve as an example to others to not mess with them. So 2 months after the petition was presented, they had Sylvia arrested under a tampering statute for trying to steal her own petition. They argued that she did so by putting the petition in her binder while standing next to the mayor while everyone was watching and while she was thanking a staff member for giving her a bottle of water, some criminal. The magistrate signed the warrant for Sylvia's arrest, since the statute is so broad that it even covers moving a government document from one side of a table to another. The district attorney declined to pursue the charges. But by then, Sylvia, at that time, 72, already spent time in jail, already wore an orange shirt, already was forced to sit on a cold metal bench with no access to her medications and avoiding the bathroom that had no doors for privacy. So traumatized by this entire experience, Sylvia gave up her seat. The mayor and the city manager still run Castle Hills today. We sued for First Amendment retaliation, saying that they really arrested her not because of probable cause, but because they did not like what she had to say. But the Fifth Circuit, over Judge Oldham's dissent, told us that we don't have a claim. That's because, according to the court, the Supreme Court's decision in Nieves versus Bartlett imposed a general bar on retaliatory arrest suits as long as there is probable cause. Sylvia could only overcome this bar if she pointed to another person who similarly misplaced a petition but was not arrested for it. Kind of like with an earlier example of jaywalker, that you had to point to a specific person who jaywalked and was not arrested for it under similar conditions. The implications of that decision being allowed to stand would have been enormous. Probable cause, as viewers know, is an extremely low bar, especially when it comes to statutes like this one that cover a whole lot of conduct, including innocent conduct. If probable cause can be used as an excuse to launder First Amendment violations through these types of statutes, then sky is the limit for those intent on punishing their critics. We are seeing this happening in local governments all across this country. Just in the last year and a half, I can count to at least 5 examples, and that's just what I've run into. The first example is from Escambia County, Alabama, where last October, a newspaper publisher and a reporter were arrested after the newspaper published an article about a school superintendent misusing COVID-19 funds. Turns out the superintendent, as in our case, is very close with the sheriff and the district attorney, so the powers that be. And apparently it is a crime for news media to publish material leaked to them by their sources. So off to jail they went. Another example is out of Surfside, Florida. This is really diverse all across the country. And the Surfside, Florida situation, this March, a teenage activist spent 27 hours in jail after he posted a video questioning the mayor about his trip to Dubai. The student was accused of felony assault by the mayor's ally, but 2 minutes of witness interviews would have established that he did not lay a finger on the man. Example number 3 happened in Newtown, Iowa. That's an IJ case, where a 22-year-old critic of the mayor was twice arrested after twice calmly speaking in public meetings. Example number 4, Trumbull County, Ohio, where a local politician spent a day in jail after she criticized the sheriff for abominable jail conditions. And example number 5, we all remember, a police chief conducted a raid on a Marion County newspaper late last August. Actually, not late last August, first half of August, after the newspaper investigated him for his troubling past employment history. So the government in one of these cases, back in the day, argued, not in Gonzalez, that these kind of situations are a needle in a haystack, but clearly that's not the case. thankfully, the Fifth Circuit's decision in Gonzalez was not allowed to stand. So hopefully we'll see less of this going forward. On June 20th, the court issued an opinion that vacated the Fifth Circuit's ruling and remanded the case back to the lower courts. The main per curiam opinion, which every justice signed on to, other than Justice Thomas, explained that the only express limit placed on the threshold evidence is that it must be objective. So long as this objective evidence, in a court's estimation, makes it more likely that an officer has declined to arrest somebody for engaging in such conduct in the past, but for some reason is not exercising this discretion now, the case should be allowed to proceed. The court explained that Sylvia presented such objective evidence. For example, in our complaint, we stated that we conducted a survey of felony indictments and misdemeanor records that showed that people who are generally arrested under the tampering statute are accused of faking green cards, faking driver's licenses, faking social security cards. And which means that this tampering statute, after looking at this data, had never been used in their county to criminally charge someone for trying to steal a non-binding or expressive document. So this evidence, this survey, in the court's view, satisfied the Nieves standard. And the Fifth Circuit was wrong to rule that it doesn't. That's the majority bottom line. Justice Alito wrote a concurring opinion where he provided more guidance. For example, he explained that objective evidence means anything other than evidence regarding an officer's state of mind. For example, evidence of bad blood between the officer and the speaker is not going to be allowed. But if you move beyond subjective motive of why the officer did what he did, then that's objective evidence. So by this definition, evidence that we provided, in addition to the survey, also qualifies. For example, we allege that defendants did 3 unusual things that ensured that Sylvia, who is 72, is wanted for a nonviolent misdemeanor, has no criminal record, is a council member, that they did 3 unusual things to ensure that this type of a person would go to jail. First, they sought a warrant, not a summons. Highly unusual. Second, they circumvented the district attorney. Highly unusual. Third, they ensured that a satellite booking function would be unavailable to process Sylvia in a courtroom instead of an overcrowded jail. Again, highly unusual for somebody who is wanted for a nonviolent misdemeanor, has no criminal record, who is not a flight risk. All that is objective evidence that, according to Justice Alito's concurrence, should be allowed in. Justice Jackson and Sotomayor also wrote a concurrence and explained that in their view, objective evidence even includes statements by the special detective, one of the defendants, in his affidavit, which suggested a retaliatory motive. Justice Kavanaugh wrote a concurrence where he said that because we don't concede an intent to steal, we should not have conceded probable cause. But the statute, the tampering statute, does not turn on specific intent, and the Texas courts acknowledge as much. And that's really the problem with the criminal justice system today. As Justice Gorsuch explained in his concurrence in Nieves, the statutes are so broadly written that they can cover even innocent conduct in some situations, just like this tampering statute in our case. Justice Thomas is the only one who dissented. He wrote separately because he was not persuaded by our common law analogy to abuse of process. In response, I would only point to Justice Gorsuch's question during the oral argument, where he prefaced the question by saying that he practiced abuse of process torts when he was in private practice. And then he asked, how is this not an abuse of process tort? We agree. So the decision is good news for plaintiffs like Sylvia, like the Alabama school board member, like the protester in Florida. They can now sue their tormentors as long as they provide common sense evidence outside of allegations of subjective state of mind, that officers generally use their discretion not to arrest in situations like these, and for some reason they don't use their discretion to arrest in this situation. That satisfies this threshold requirement. Perhaps even more importantly, the court did not give any credence to the defendant's radical argument that so long as the arrest is executed pursuant to a warrant, there should be a blanket prohibition on retaliatory arrest lawsuits. This clearly is now out of the window, which we are very happy about. If anyone should get an extra degree of protection, it's an officer making a split-second decision to arrest, not a special detective who spends 2 months coming up with an affidavit to arrest an elderly woman for a nonviolent misdemeanor. What's still left open is how far the definition of objective evidence goes. Justice Thomas's dissent plus Justice Jackson and Justice Sotomayor's concurrence suggests that everything other than subjective allegations of state of mind should go in. Everything like that is objective evidence and should be allowed. So now it's really up to lower courts to explore the bounds of objective evidence. And we look forward to doing that in this case and in many other cases that we are litigating involving retaliatory arrests. The bottom line, though, is that this decision in Gonzalez is a warning to all political bosses running local governments out there. In America, we don't arrest our political opponents. If you do, you'd better be prepared to defend yourself in court. Thank you.
Great, Anya, thank you so much. I really appreciate that. So first question we have, to what extent do you think plaintiffs will rely on these concurrences as persuasive authority in the future? Should the majority opinion have done more to define objective evidence?
I think I agree with Justice Thomas in like his description of what the per curiam opinion did. And the per curiam opinion specifically said the only limitation we have is that the evidence must be objective. Purely subjective evidence of state of mind is not going to come in. So the court, in my view, is pretty explicit about this. And lower courts could certainly look to Justice Alito's concurrence, discussion of legal principles, not the discussion of facts. And Justice Jackson and Justice Sotomayor's concurrences, I think, both are very helpful in explaining what is objective evidence. Again, as Justice Alito says, you know, evidence of bad blood is not going to come in, right? You're not going to say, oh, the mayor hated Sylvia because Sylvia told him, you know, he should be nicer when he talks in public. You know, that kind of evidence can't come in at the threshold stage. But everything else is fair game. I think the interesting question and kind of a daylight between concurrences, between Justice Alito's concurrence and Justice Jackson's concurrence, is what to do with something like the affidavit, where it essentially is an admission of taking speech into account. And that's an interesting question of whether that kind of evidence comes in at the threshold stage or not. But concurrences are what they are, and we have Justice Alito writing for himself, Justice Kavanaugh writing for himself, and Justice Jackson writing for herself, and for Justice Sotomayor.
Great. And then another question is, what challenges did you face, if any, in arguing Gonzalez's arrest was retaliatory rather than based on probable cause?
Just the amount of evidence we had, and just to be able to lay it out there without sounding like a conspiracy theorist, but we do have incredible amount of evidence. For example, there is a newsletter that's coming from one of the allies of the mayor, and in this newsletter the guy is laying out his thoughts on how to remove a council member. And one of the things that they can do is to get the council member convicted of a crime. Another thing that they can do is have a citizen lawsuit based on incompetence. And both things happen in this case, right? And in addition to all this other evidence, we have this newsletter, and the challenge really, and in the complaint, it was a really big challenge, trying to organize all this evidence in a manner that makes sense, and to show that overwhelmingly, if you look, okay, probable cause on the one hand, and then all this other evidence on the other hand, it should make it very clear that it was the retaliation for speech and not probable cause that drove the decision maker, that drove the decision making by the mayor.
Great. And then, so a question I think trying to get at this question of objective evidence, and someone's wondering, kind of how is that decided, particularly regarding, if there are more people who are involved, does that contribute to making it more objective? How do you kind of define that?
Yes, it's really objective evidence is defined by what it isn't rather than what it is really. And it continues to be the case post Gonzalez. What they're saying is that subjective motivations of a particular arresting officer don't matter at this stage, period. It's kind of like they're drawing analogy with the Fourth Amendment, right? Where when you look at the conduct of the officer, you look from the prism of objective officer rather than the specific officer and what was going on in his head. So this is really what the court is most worried about. The court is saying we're not going to be opening up the brains and looking at what was happening in their heads, at least at this stage, right? And that is very clear. Other than that, you're just looking to objective evidence, including like Justice Jackson and Justice Sotomayor say, objective statements in an objective document about how speech was taken into account while deciding whether to arrest. That it doesn't go really to the head of the particular person. It's really going to the objective facts in the world. And that's, I think that's the key here is to always think back to subjective motivations of a particular arresting officer don't matter. Subjective motivations of Mayor Trevino, of Chief of Police Siemens, of the Special Investigator Wright, don't matter at the threshold stage. They will matter once the case proceeds to discovery. But at the threshold stage, the burden is on us to provide evidence that is other than us telling the court that somehow the mayor didn't like Sylvia. And we provide that kind of evidence.
Great. And then we have a question that says, how do you anticipate the court's decision will play out after running into qualified immunity, especially the clearly established law prong?
Yeah, that's a great question. The district court decided in our favor, saying that that Nieves and Lozman clearly establish that this is a constitutional violation, putting reasonable officer on notice that doing this, even if there is probable cause, could violate someone's constitutional rights. And we're optimistic that we will overcome that threshold requirement, that the district court will be able to proceed with the case past motion for summary judgment, past motion to dismiss. And one thing I'll say about the Fifth Circuit, especially in its latest jurisprudence, they've been really good and especially just Judge Oldham, really good at kind of separating, at looking at this idea of fair notice, clearly established law, as a dynamic inquiry, right? So what is fair notice for a police officer making a split-second judgment to use force is very different than what's fair notice for a special detective who is spending 2 months concocting an affidavit. So when it comes to fair notice with police officers, the Fifth Circuit is very clear. You have to look at it with a very specific degree of similarity. But when you are talking about a First Amendment violation, for example, and plenty of time to deliberate, then the level of specificity does not have to be as exacting, because you don't need that level of specificity to provide a reasonable officer with fair notice.
Great. And so another question on, so Justice Alito's presentation of the facts of the case, and I think someone wonders that it seems to kind of imply, his presentation seemed to imply bad faith on behalf of Mrs. Gonzalez. You know, what would you have to say about that?
That's why I'm urging people to pay attention to his legal analysis, not to his factual analysis. With all due respect to Justice Alito, we are at the motion to dismiss stage. We presented our facts very clearly. We do not concede intent to steal the petition. Everybody can watch the video and see Sylvia, taking this piece of paper from one side of the table to another side of the table, and there is a staff member bringing her water. And as she's doing this, she's also thanking the staff member. The facts need to be at the motion to dismiss stage, especially taken in our favor. But even beyond motion to dismiss, we're confident that we will convince the court and then members of the jury that Sylvia's completely innocent.
Great. And then another question. So someone is curious about a particular question posed by one of the justices, asking whether the argument you were making was kind of really in the client's best interest. What was your response to that question?
I guess that all goes back to this idea of conceding probable cause, which is, again, the magistrate signed off on a warrant. The statute is written so broadly. I encourage people to go even look at the interpretations by Texas state courts of that statute, that it covers even innocent conduct. So we ran into this issue with the magistrate signing the warrant. And given that we have that issue, we had to present the evidence to overcome that. And the Supreme Court said we did. So hopefully now we can move beyond that and continue to discovery. Sorry, Caroline, I think you're on mute now.
Thank you. I appreciate that. So another question. So during your oral argument, were you surprised by any of the points of contention that came up during your kind of presentation, any back and forth, your thoughts on that?
It was I'm just trying to, one of the things that we were really worried about is that argument that defendants made in their papers about how the existence of a warrant essentially should provide blanket immunity to somebody like the mayor and the police chief. As long as there is a warrant, nothing you can do. There isn't even this exception to Nieves. It's like a prosecutorial immunity, like the retaliatory prosecution types of cases. That argument, we were surprised that it didn't really get much play during the oral argument, and it didn't get any play at all in the decision. So pleasantly surprised and very happy about that. So this is one of really great things to see come out of this, that this kind of a thing has no purchase at all, and warrants can't be used as a way to launder a First Amendment violation. Like the Marion County raid, right? There was a big to-do in the news about how there was a warrant for the raid of the newspaper. And again, once you read that warrant, right, it's like, oh, unauthorized use of a computer. There is a statute that can cover, anything, including going on a website and punching in, a search term. You can get a warrant for that. And warrants should not be used as a way to excuse a First Amendment violation. So that was really great to see that neither during the oral argument nor in the opinion writing itself, anybody gave any credence to that.
Great. And then one final question, unless there are any more submitted from our audience. What, if any, are the implications of your case on the criminal cases against former President Trump?
Caroline, you told me earlier that I can decline to answer certain questions. I think I'm going to use my privilege here on that.
Absolutely, absolutely. Well, on behalf of the Federalist Society, I want to thank our speaker, Anya, for the benefit of her time and expertise today. Thank you also to the audience members who joined us. We greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming webinars. Thank you once more for tuning in. And with that, we are adjourned.